One of the immediate questions that comes to mind is basically the countries that are affected. So I know these cases at CIT were specifically about China, Mexico, and Canada. But I've heard you say before that this is, this ruling is going to affect all IEEPA tariffs, right? Basically every country that, so how does that work if those countries aren't challenged? Is that like a direct sort of, if Supreme Court says IEEPA, was not legally used, therefore it shouldn't apply, does that automatically mean every country that was subject to it? Or is there some kind of a procedural thing that needs to happen?
So there's a three-part answer to that question, and they all have to do with cases and decisions that came from the CIT. The first is the Court of International Trade has said right up, just right out front, we are not going to limit refunds. If this is a situation where there are refunds, we will not stand in the way of refunds happening. The second interesting decision was one where the court said, rather than retry this under the same basis as what we just went through, we're going to say that all IEEPA tariffs fall under this, and under this decision by the Supreme Court. If it's IEEPA and it was done, we're not going to sit here and retry it and waste the government's money and the importer's money.
So it's like a precedent, basically, that would be applied instantly to.
That's a good way of putting it. Neither one of us are attorneys. I'm a failed comedian with a broker's license and a PhD in economics. So, I'm doing the best I can, folks, but I'm trying to explain it in a way that all of us can understand. The precedent idea is a great way to look at it. Why would we just retry all of this? So they came out with a decision, and they said that the invalidation of IEEPA by the Supreme Court, we will direct that towards all other origins. And that was some excellent news. The third decision, which is pretty big, was when they said that there is an existing administrative process to get this money back that Customs has used for quite a long time through post-entry adjustment and protest. We're not going to get this wrapped up in court, which was interesting, right? Because for a long time, many of us, myself included, were saying that the liquidation period could really end up being a thorn in the side of importers, trying to figure out how we're going to get this back if the timing is off. You've got a very short window of time to do a post-entry adjustment. That's where someone made a mistake or someone got new information, so we're making a change. The protest is you have 180 days after liquidation. And liquidation, for those of you who don't know, is when the government says we're closing the file on this transaction. We're not looking at it anymore. You don't have to look at it anymore. Just keep all your records in case we have questions down the road. And you get 180 days to protest that decision. And 180 days, seems like a long time, but it really isn't. When you think about the information you have to gather in order to get to the government in time, being super honest with everyone, very few importers, do little, if at all, any post-entry audit, very little. And even fewer have what I would consider to be even mediocre record keeping to pull what they need to do it. So 180 days isn't that long. And a lot of this stuff would have fallen out of that period. So the early days of this, back in April the 2nd, when I stopped trimming my beard, we had tariffs not long after that were in the 125, 145% range. The ones that were hit the hardest would probably not see a refund because they fall out of that window. The court said, we will find a way to make every entry, every opportunity available to the importer, which leads most people to believe that they're going to extend the period past liquidation, where there'll be a period of time. For a lot of folks speculate, when you go to DC and you have a couple dozen Manhattans with people that know more than I do, they'll say to you that they wouldn't be surprised if it was 2 years, where you could gather the information, audit your entries, make sure it's correct, and submit it within that period. And the government has a statutory amount of time to respond, but it won't be that way. They'll be overrun with the refund requests. Sorry, go ahead.
So couple of notes on that. So, you've done many years, being a customs broker, so you know how this works. Like most importers have used different brokers, different forwarders, so the information is all over the place, right? It's not, I guess the larger ones tend to be more organized, but a lot of the medium and smaller ones, the very obvious thing is a lot of them have used multiple brokers. So first of all, I can totally see how 18 months is not enough, right? Or Yeah, basically 18 months. Is it 18 months? So you have 364 days for liquidation, and then another, I guess, a year and a half, right?
314 days or 341. I always mix those two up. And then
Yeah,
180 days past that. It's not a lot of time. No.
yeah.
Which is why
So, so if you're lucky, you have one organized broker and they have proper
yeah.
record keeping, but probably not, right?
Well, not just that. It's not the broker's responsibility to keep the records. I mean, the broker keeps them for themselves, but the records are supposed to be kept by the importer, which in and of itself is a problem. I mean, most customs house brokers use an internal system, say CargoWise, or one that they've developed themselves, which does keep all the information, and that's great. But it's not the responsibility of the broker to keep those records. It's the responsibility of the importer. And you can't say, well, my broker's got them all. I'm begging all of you, if you're ever in an audit, that it's not the response to where your records. My broker has them all. That will end in nothing but peril and disappointment for all of you.
But Pete, in practical terms, I assume, and I say this as I'm not a licensed broker, but I own a company that's a licensed broker. So we kind of expect to be there when this is needed, right? So we have typically we would have like a entry summary, right? The commercial invoice packing list, any other documents that are, what are we talking about? Let's get into it. So let's say a typical audit. Let's not get into what IEEPA is yet, but a typical audit. What do you actually need to produce as an importer?
You're missing key elements in the brokerage file for an audit. There are two huge ones. The first is the purchase order. It is uncommon for the purchase order to be resident in the file. Why do we want a purchase order? Because it shows what the original negotiated price was, the conditions of the sale, that's all there. The second is the proof of payment. So the proof of payment, some sort of a proof in the transaction between the importer themselves and the bank that shows the amount that was actually paid to the foreign supplier. Because things go wrong, things change. It's not uncommon, right, for a 40-foot ocean container to show up at a warehouse, and because containers are made from garbage, there was a hole in it and half of the boxes are wet, so now we have an insurance claim. Great. You work that out with your foreign supplier. But as a customs house broker, I don't know that. I made entry on the information available at time of entry, so I need those. The third piece, which is going to be crucial, is proof of payment of the duties. And think about that from a broker's perspective. A lot of your clients, I imagine, maybe even still now, expected you in that period to pay the tariffs on their behalf, and then they would pay you once you billed them. Well, now we've got to prove that the broker paid it and that you paid the broker for those tariffs. So there's two more transactions. It's not so much what I'm worried about in the middle of that entry, which, yes, many brokers are doing. It's the other parts associated with it. And then for companies that have jumped from broker to broker to broker to broker, they're going to have to go into ACE, pull all the information down to look at the filer number to see who filed on their behalf, contact them for that information. It's just going to add time to it and expense. But that's realistically where we're going to be if this were to happen the way we hope it does.